Good day, and welcome to Epstein Becker Green's webinar series focused on non-compete agreements and key considerations for healthcare employers. Before we begin today's presentation, please be informed that the webinar is being recorded and that participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx, and at the end of the program, with time permitting, the speakers will address your questions. You are also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to PowerPoint materials. We are pleased to have wonderful speakers today. In that time, I would like to turn the webinar over to Nathaniel Glasser.
Nathaniel Glasser. I'm a partner in the Washington, D.C. office of EBG and a co-leader of the Health, Employment, and Labor, or for short, Strategic Service Team, which is hosting this webinar in conjunction with our Trade Secrets and Employee Mobility Service Team. Today's webinar leverages the 2 key practices of EBG, healthcare and labor and employment. I'm happy to be joined today by distinguished colleagues around the country who specialize in these areas. Dadika in Newark, Dave in New York, and Kevin Ryan in Chicago. As in data have each become more transferable, employee mobility has taken on increased significance. This is not just for industry players looking to protect their proprietary interests, but also for the federal government, which has put renewed focus on restrictive covenants and anti-poaching agreements. These are particularly acute for healthcare employers seeking to protect secrets, retain employees, and, especially in the case of providers, prevent patient loss. Restrictive covenants, especially for physicians, take on added significance. And those of you following the news or receiving updates from HLA know that the announcements of mergers and acquisitions in the industry come almost daily. These actions, whether big or small, involve the transfer of human capital, and both evaluating existing non-competes and fashioning enforceable restrictive covenants for acquired employees becomes critical for those involved in these deals. Should your organization approach and best leverage non-compete agreements effectively in these circumstances? Our team will offer some answers to these questions as they discuss the current legal landscape, key drafting and enforcement considerations, how to approach non-competes in the due diligence phase of a transaction, and integrate providers upon completion of a healthcare transaction. I'd like to turn the webinar over to my partner, David Clark, a commercial litigator who focuses on matters involving trade secrets, restrictive covenants, and other employee mobility issues. Dave will discuss the legal landscape of non-compete agreements in the healthcare industry.
Nathaniel, this is David Clark, and as Nathaniel said, restrictive covenants are indeed common in the healthcare industry, particularly in connection with acquisitions or mergers of healthcare practices or businesses. Many physicians and other healthcare workers are familiar with restrictive covenants, either employees who have been asked to sign such covenants as addition to their employment, or business owners seeking to enforce such covenants to protect their medical practices from competition. These covenants are usually intended and designed to prohibit physicians or other practitioners from leaving, setting up a competing practice nearby, using patient contacts, information, and perhaps training that they received during their employment or association with the former employer. And just so everyone's clear on this first slide, we're talking here about contracts that limit post-employment activities of individuals. These will commonly take the form of non-competition provisions, agreements not to solicit former patients or clients, agreements not to solicit former coworkers or other employees, and even confidentiality provisions. Health transactions often include a host of restrictive covenants, which may be contained, for example, in purchase agreements, service agreements, management agreements, and commonly in employment agreements. Before we delve into healthcare restrictive covenants, let's talk generally about some things regarding restrictive covenants in any industry. Covenants generally are regulated by common law, i.e. judicial decisions, and sometimes state statutes, which can differ markedly from one state to the next. There's federal statute governing restrictive covenants yet, although there have been recent proposals in that direction. So we look pretty much exclusively to state law on these issues. But how does one know which state law governs? It'd probably be the law of the state in which the individual being restricted resides or works. Or it might be the law of the state in which the employer is located or is headquartered. But it could otherwise. Maybe the agreement specifies a different state's laws should govern. If so, it's likely but not guaranteed that the specified choice of law will be given effect. It's crucial to know which state law governs because they can vary widely. For example, states allow covenants not to compete or not to solicit when limited in scope, reasonable time, and geographic restriction. In other states, like California, covenants not to compete are expressly prohibited in most employment circumstances. In California, in the context of a sale of a business, they may not be prohibited. So I said there's potentially wide variation in enforceability of non-compete and non-solicitation restrictions depending on the state. In contrast, confidentiality agreements may be enforced pretty much in all states with few limitations. If we're talking about physicians and some other healthcare professionals being subject to restrictive covenants, there can be an additional level of complexity in the analysis of such covenants. Because many states, in the unique position the medical profession holds in the public interest, apply special rules to covenants that restrict the practice of medicine. So several important public policy considerations are often at play when discussing a restrictive covenant binding on a physician or healthcare worker. The paramount consideration usually is the right of patients to obtain treatment from the physician or other healthcare professional of their choice. The covenant infringing on that right is highly likely to be unenforceable. Considering such covenants also may ask whether enforcement will cause a shortage of doctors in a particular area or within a particular specialty. This is more of a concern in areas with lower population density and not that big of a concern in urban areas where doctors are usually in plentiful supply. The interests of the patients in terms of access and choice are most important. A countervailing interest, of course, is the doctor or healthcare worker's right to earn a living and determine where and for whom he or she would like to work. And, layered into these competing considerations are the questions of whether the restrictions are reasonable in scope, time and geography, or in the class of clients and patients that must not be solicited. So let's take a look more closely at state laws limiting restrictive covenants in the healthcare context. By statute, several states that may allow non-competes generally, provided they're reasonable and protect legitimate business interests, will not enforce them at all against physicians. In 1977, Massachusetts was an early adopter of a statutory prohibition on physician non-competes. Massachusetts General Law, Chapter 112, Section 12X, renders void any non-compete provision restricting the right of a physician to practice medicine in a particular locale and/or for a defined period of time. So in Massachusetts, there's a blanket rule: physician non-competes are void. In the 1980s, Delaware and Colorado enacted somewhat similar laws to the one in Massachusetts. In both states, a physician who signs a non-compete of, say, 6 months within 25 miles of her location will not be forced by a court order or injunction or otherwise to adhere to those terms. She can open a practice immediately right next door to her prior location. But note, under Delaware and Colorado's non-compete statutes, they violate a non-compete, physicians can be required to pay damages reasonably related to the injury suffered by breach of any such agreement. So, Delaware and Colorado, no injunction to enforce a non-compete, but possibly money damages against a physician who violates the non-compete. Further wrinkle, earlier this year, the Colorado statute was amended to carve out that certain physicians who are treating patients for a rare disorder, and that's defined in the statute now, will not be subject to claims for damages if they disclose their continuing practice and provide new contact information to any such patient. 2016, Rhode Island got into this act and enacted a law just like Massachusetts' statute. Rhode Island General Laws, Section 5-37-33, also simply renders physician non-competes unenforceable. So if our physician employee in Brooklyn who previously signed a non-compete quits and immediately opens her new office right next door, there's really no remedy available for the former employer. They can no injunction and no damages against that physician. He could be violating a compete. So those are state laws which really basically prohibit physician non-competes. Look at some other states. I'm going to 4 states that do not prohibit physician non-competes, like Massachusetts, Delaware, Colorado, and Rhode Island do, but rather apply stricter standards to such agreements than they do to employee non-competes generally. For example, Tennessee statute enacted in 2007 and amended several times thereafter, a physician, including radiologist, non-compete provisions if they were in writing last longer than 2 years after the physician's employment is terminated, and B, either A, are geographically limited to the greater of the county where the physician is employed, or a mile radius of the primary practice site. Or if there's no geographic restriction, the physician is restricted from practicing at any facility in which employer provided services during the physician's time of employment. Texas law allows physician non-competes, provided that the covenant must satisfy certain statutory conditions. The non-compete must allow the physician access to a list of the patients seen or treated within 1 year prior to termination of employment. It must provide access to medical records of the physician's patients upon proper authorization. It must provide for the option of a buyout of the covenant by the physician at a reasonable price. And it must allow the physician to provide continuing care and treatment to a specific patient or patients during the course of an acute illness. Turning to New Mexico, Mexico statute first enacted in 2015 provisions in agreements which restrict the right of healthcare practitioners to provide clinical healthcare services. This is a pretty broad-ranging statute. It defines healthcare practitioners as physicians, osteopathic physicians, dentists, podiatrists, and certified registered nurse anesthetists. And the list was first expanded by amendment earlier this year to include certified nurse practitioners and midwives. All of these folks, if any agreement they enter into purports to restrict their right to provide clinical healthcare services, that provision is unenforceable. The law, however, does allow non-disclosure provisions relating to confidential information. It allows non-solicitation provisions of no more than 1 year. It allows reasonable liquidated damages provisions if the practitioner does provide clinical health care services of a competitive nature. under the New Mexico statute, healthcare practitioners employed by the practice for less than 3 years required upon termination to pay back certain expenses to the practice, including loans, relocation expenses, signing bonuses, or other incentives related to recruitment and education or training expenses. Finally, Connecticut law enacted in 2016, rather than prohibiting physician non-competes, limit the allowable duration and geographic scope of any new, amended, or renewed physician agreement. These are up to 1 year and up to 15 miles from the primary site where the physician practices. The Connecticut law also renders physician non-competes unenforceable. Physician's employment or contractual relationship is terminated without cause. So most of these laws that I've discussed were enacted and amended in the last 10 years or so, and in some cases amended even earlier this year. Other states already are or will be considering enacting statutes restricting competes and related restrictive covenants for healthcare providers in the future, which is certainly toward limitations on such agreements in the healthcare field, as well as toward more limitations on such agreements in fields beyond healthcare. Accordingly, consultation with local legal counsel regarding these issues is highly recommended for any person or entity practicing in the healthcare industry. Back over to Nathaniel.
Thank you, David, for setting the stage. Now we'll turn to Denise Dadika, who is a co-leader of our HEAL group and works with many clients in healthcare and the life sciences, and she'll discuss addressing key considerations for employers when drafting and enforcing non-compete agreements.
Daniel. As David just explained to you, non-compete agreements are governed by state law, and those state laws are going to vary widely. So when you start to draft your non-compete agreement, it's important to understand which state law will govern so you can ensure the terms that you're drafting and would like to enforce are likely to be upheld in that state. David did indicate you can select a choice of law forum within your agreement. I would suggest to you that the most narrow approach in doing that is identifying the law where the employee works as the law that governs. There may be other considerations that come into play, and you may want to enforce the law where the employer is located. Depending on your jurisdiction, that may or may not be enforced. I just want to share how critical this is with you based on a situation I was assisting a healthcare client with just a few weeks ago in assessing the enforceability of a non-compete agreement against one of its recent hires. The new hire had worked for a company in North Carolina. The company was based in North Carolina. The new hire provided the services in North Carolina, and the customer base was also in North Carolina. That had gone through a number of acquisitions over the years, and the employee at issue had entered multiple non-compete agreements as the employer changed hands. And the most recent non-compete agreement that was being sought to be enforced provided that Delaware law was the law that governed the agreement. And I mentioned all the contacts were in North Carolina. So ultimately, the matter was commenced in North Carolina, and the North Carolina law declined to apply Delaware law. There were a number of reasons for that. One, there were really no contacts other than the fact that, as I mentioned, the entity was incorporated there. But Delaware law also varied widely in terms of what was and wasn't enforceable as compared to North Carolina law. And ultimately, the agreement that was trying to be enforced did not have due consideration under North Carolina, and the North Carolina court decided we're going to apply our own law, and there's not a valid agreement. So that just highlights for you how important it is to understand what laws could be at play. And even if you're going to decide to choose the law where the employer entity is located, you should also be sure to review the law where the employee is located so you can understand what the distinctions are in the event the choice of law that's applied is where the employee is located, so you can determine what may or may not be enforced. You're also going to want to ensure that you have adequate consideration for the non-compete agreement. A non-compete agreement is a contract and it has to be supported by adequate consideration. Some jurisdictions, continued employment will be considered adequate consideration, and in others it will not, just in the example I just explained to you. So in those jurisdictions where you have to provide something in addition to continued employment, it could be in the form of a one-time bonus, a salary increase, access to confidential information that wasn't otherwise available until the agreement was entered into. It's important as a best practice to specify within the agreement the consideration that's being provided. And that's going to ensure that you don't have any factual disputes down the road when the employee exits and maybe there's some changeover within the organization. So everyone's clear as to what the consideration is, you have a record of it, and it's set forth in the agreement. Okay, it can also include a forum selection and a venue selection within the agreement. Again, this will be governed by state law as to whether it's enforced, but it generally will be unless the exiting employee can demonstrate that there is an undue hardship against him or her. For example, they may not be able to travel to the forum for certain reasons. A provision that you're going to include in your non-compete agreement is the definition of business and employer. And as we continue to see consolidation within the healthcare industry, employers are becoming larger and more healthcare employers are becoming affiliated. So the how you define employer is going to be critical. While you may want to define the employer or business as broadly as possible, you have to keep in mind that the restrictions that are going to be included in the agreement are going to have to balance against that broad definition to ensure that it's going to be enforced and it's not going to be deemed unreasonable by a court of law. This will include a assignability provision within the agreement, and that allows for the non-compete or the non-solicitation provisions within the agreement to be enforceable by a third-party successor or assign. And that's important in the sale of business context and as we continue to see the consolidation to ensure that the new employer can stand in the shoes of the original employer and can enforce the agreement. Okay. In order for a non-compete to be enforceable, it must be supported by the employer's legitimate interests that are worthy of protection, otherwise known as the protectable interest. So it's very important that you're able to identify those within the agreement because courts will not enforce agreements simply to prohibit competition. So you have to be prepared to articulate within the agreement, and then when you go to enforce the agreement, what business interest supports the agreement and the restrictions set forth therein. The number of protectable interests, secrets is one of those protectable interests, and that's information, methods, formulas that drive an independent economic value. Trade secret information is not publicly available, and the employer needs to take reasonable measures to protect the information. You do that by using confidentiality agreements, employing password-protected systems to make sure that that trade secret information is only distributed to a limited number of people. Confidential information is also a protectable interest that you're going to want to identify in your non-compete agreement. Be sure to specifically identify it based on what your interests are as an employer. It should not be one definition for all employers. You should specifically identify what is of most interest to you and what the individual you're trying to restrain will have access to. Another protectable interest, and most likely one of the most important ones, is going to be the patient base. So identifying patients as a protectable interest. Also, relationships you have with referral sources, relationships with hospitals, and then finally, training could also be a protectable interest. Training can't be general training. It's going to have to be some form of specialized training, whether that's providing, for example, surgical training or other specialty training that the individual would otherwise receive from another employer. So by the protectable interest at play, you then define the restrictions to ensure that the interests are protected. You need to make the agreement as specific as possible sure that it's going to be enforced. This is not a one-size-fits-all. You have to look at the relationship you have with the employee that you're trying to restrain, what they're doing for you, where they're doing it, and the interests that you're trying to protect, and then craft those restrictions as specifically and narrowly as possible so that you're protecting the interests of the employer without being unreasonable to the employee. Non-competes are going to have a temporal restriction, and that is going to be the period of time that the individual is restricted from engaging in the other activities that are going to be listed in the agreement after they separate from employment. Generally, 1 to 2 years is reasonable in the healthcare industry for physicians and practitioners. It will vary based on state, and it's also going to vary based on what the other restrictions are and the scope of those restrictions in the agreement. When we're talking about a transaction and there's a sale of a business, typically we see restrictions of 5 years that have been enforced, so you get a greater restriction when you have a sale than you're simply trying to restrain an employee. The restriction is a geographic restriction, and that will where the individual works and how broad it's going to be. In urban areas, we see much smaller geographic restrictions deemed to be reasonable as compared to suburban or rural areas. You're going to take a look to see, where's the patient based from? Where is the employee working? And for example, if 75% of your patients fall within a 30-mile radius, you probably limit the geographic scope to 30 miles and nothing beyond that. You're also going to want to limit it to where the employee served. So when you're talking about practices or healthcare systems that have multiple locations, it's likely to be deemed unreasonable if you have a restriction that says within 10 miles of any of the locations of the employer. So if the individual provides services at 2 of the locations and they have done so for the last 2 years, it's likely to be deemed reasonable to restrict the individual from practicing within so many miles of those 2 locations where he or she served. Instead of geography, you can also consider framing the limitations in terms of the type of employers the employee is prohibited from providing services for. For example, if you're a hospital, you may not be concerned with an employed physician establishing his or her own practice, but you may want to restrict the physician from providing services to his or her patients at a competing hospital. So in that situation, you may forego a geographic restriction and instead identify specific competitors that the individual cannot work for the period of time that they're restricted. You'll look at the services the individual is providing in terms of, the specialty, and careful in terms of your limitations. If the individual is certified in more than one practice area, but they're only providing ER services for you, crafting a restriction that's going to prevent them from providing any type of medical services in the future to another practice for a period of time is likely to be deemed unreasonable. So you really have to look to see what services and benefits the individual is providing for you and craft the restrictions as to those benefits and services. And that becomes important when you're talking about multi-specialty medical practices, to be careful to focus on the practice area the individual you are entering the agreement with practiced in. Source is another type of restriction that you can include, depending on the applicable state law, including medical ethics of your state. An employer may be able to preclude a former employee from contacting or accepting referrals from a referral source that they established or had been established at their prior employer. Your patient base as well. The best means to do that is by creating a non-solicitation agreement that limits the exiting individual from directly or indirectly soliciting or encouraging patients to follow them to their new employer. You're going to have to take a look at the time period when you're crafting that provision. Reasonable, it shouldn't be, any patient they've ever treated at any period of time. You may want to consider patients they treated within the last 12 months or the last 18 months they were employed with you. Hospitals can also be addressed in in terms of restrictions. It may be that you are part of a practice or you're a practice group and you may have an exclusive relationship with a hospital to provide all of their radiological services. And one of your radiologists leaves, you want to make sure that you're protected from that radiologist trying to do work for the hospital. So you can specifically identify within the agreement that the individual can't provide any services at that specific hospital. It's important to consider getting permitted activities with non-compete. And the reason for that is twofold. It makes clear to the employee what they can do, so it demonstrates to them that there are services and areas of practice they can still provide. And it also demonstrates to both the employee and to the court that the restrictions that you created are not reasonable, because there's this whole area where they can still continue to practice the area of medicine in. After you drafted the restrictions, which is really the focus of the agreement, there's some other provisions you're going to want to include. You should consider including acknowledgments. If you have a geographic restriction within the agreement, you may want to have an acknowledgment from the physician, and the physician agrees that the field in which they practice is not in short supply within the geographic or the neighboring zone that's restricted in the agreement, and this is to help defend against any future claim that the geographic restriction is too broad and it compromises patient care because there is a short supply of physicians in that area. Acknowledgement you could consider including is an investment acknowledgement that you've invested specialized training and time with the individual to develop a skill set that they did not have before they entered your employ. Acknowledgments as to temporal and geographic restrictions as being reasonable and not prohibiting the physician from finding alternative employment should also be considered. You'll include an injunctive relief provision so you can obtain injunctive relief to prohibit a further breach once you have information that the individual is acting contrary to the restrictions in the agreement. In terms of transactions, you should also consider a liquidated damages provision. For example, you may have a seller physician who sold you the practice, and you may want to include a restriction in terms of most for the number of, for example, 5 years. You could include a provision that says in the event the physician breaches in one of that 5-year restriction, they're going to return 80% of the purchase price. And you can include a sliding scale, so if they breach in year 4, they're going to return 20% of the purchase price. Include tolling provisions, which is a temporal restriction in the agreement that provides temporal restriction in the agreement will be extended by any period of time the employee was in breach before the injunction is granted. So you still get the benefit of that period of time you defined in the agreement in terms of them being restricted. To include modification and severability agreements. The agreement is going to help to ensure that if any of the provisions are thrown out, the remainder of the agreement is still in force. And then reformation is important, and the state law varies greatly in terms of what state courts will do if they find that some of the language is unreasonable or overly broad. So many of the states follow reformation, which means that a court can actually rewrite the terms of the restrictions if they find that they're unreasonable. So you may have a third restriction and the court finds that that is too broad and they're going to change it to 15 miles, but they're still going to enforce the geographic restriction against the individual. Some states will not rewrite the provisions, but they will strike language that they find to be unreasonable. For example, if you have a list of competitors that the individual is precluded from working for, they may find that that list is too great and it's overbroad, and they will strike some of those competitors from the list. And then finally, there are some states, for example, California, Virginia, that prevent any type of modification. And if covenants and restrictions are deemed unreasonable, they will be thrown out. So if there is a chance that the non-compete agreement you're entering into is likely to apply, the courts are likely to apply California or Virginia law, you have to be very, very mindful in crafting your restrictions as narrow as possible to ensure that they will be enforced. Okay, generally spoke about the reasonableness when we were talking about drafting the provisions, and that's what courts are going to look to when they're deciding what's enforceable. There's going to be a balancing of the employer's interest against the ability to practice medicine, and also against the patient population. Is there adequate supply of people in this specialty? Will it impact patient care? You may have a broad time period, but if you're going to have a broad time period, you're going to probably have to modify the other restrictions to be less severe. So you might have a small geographic restrictions or vice versa. You might have a broad geographic scope, but it's only limited for a 6-month period. So there really is a balancing amongst the restrictions to make sure that the interest is being protected with an unfair restraint on the individual who's seeking to practice medicine. Courts will focus on public policy arguments in the physician field more than any other because they want to make sure that the patients are being cared for adequately. Things that they're going to look for, as I mentioned before, is there a shortage of physicians? Can the individuals get the care they need? They also want to make sure that the physician is not restricted from practicing medicine in the state that they're licensed. So if there's an overbroad geographic restriction and the individual is only licensed within a certain state, and that's going to prevent the individual from practicing medicine, those are likely to be struck as unreasonable. So employers should invest the time in identifying the protectable interest and crafting specific non-compete agreements that narrowly define those restrictions to protect the interest, to minimize the risk that the restrictions will be deemed overly broad and potentially unenforceable.
Thanks, that was very helpful. Finally, we'll turn to Kevin Ryan, a member of our Healthcare and Life Sciences group who concentrates his practice on healthcare regulatory and transactional matters, including working with providers and private equity companies on acquisitions. And given the increased healthcare consolidation, we'll address non-compete agreements in the context of the due diligence process and the subsequent integration of providers following such a transaction.
Thank you, Daniel. Denise just talked about were how you should do it and some of the states and whether they enforce it or not. But if you're involved in a transaction, which many of our clients are, you're going to want to see, well, how did parties that were involved with, how did they actually handle these types of agreements? Did they do the things that were talked about, or do they have agreements in states that aren't even allowed? And so as part of many transactions, there's going to be a due diligence process where you may have documents in a virtual data room. It's rare anymore that you actually have to go on site and review them, but you have a virtual data room that has a lot of different areas that you're going to consider. But one of the areas that we'll talk about right now is the contracts and the restrictive covenants specifically. And so if you're going to do this due diligence review, you need to look at did the parties that you're doing a transaction with, have they handled the contracts appropriately? So great. If not, how are we going to address it? And not only how are they handling their existing contracts, but if we're going to do a transaction, how are we going to move forward with the same parties that may have new contracts with new restrictive covenants or agreements. These types of transactions can be any number of things. It could be a purchase agreement, which could be a stock or an asset deal. It might be a joint venture or a partnership where you have both sides doing due diligence. It could be a merger. Or it could be a financing where you have a lender coming in and looking at transaction documents, historical documents for a particular provider. And the transaction may impact the enforceability as both David and Denise mentioned, and this may be particularly in states that may not allow any covenants not to compete unless it's a purchase agreement or some specific transaction document where there was consideration paid for the purchase of a business. The parties to the transaction, you're going to want to make sure that you know, is it a facility, is it licensed? And even if you're dealing with facilities that may have licenses, are the contracted parties those licensed entities? Are they unlicensed entities, which the providers have, unlicensed subsidiaries or affiliates? Are they contracts with key individuals or not? So engage in the due diligence process. Usually you've sent out a diligence request list, and you've requested specific things related to the transaction. On the health regulatory side, where I frequently work, you're asking for permits and licenses. You're asking for information regarding HIPAA. You're also asking for contractual relationships. And so usually are looking at employment agreement, management agreement, purchase agreements, vendor supply agreements, and depending upon the transaction and the parties, you can have thousands of documents. So there's a lot that you might be having to look through, and so therefore it's important that you're able to really target what it is you're looking for within these different documents. So for employment agreements, you know, is this a medical director? Are they providing professional services directly to the public, or are they employed for administrative services, or is it a combination of both? Is the management company providing services to professional facilities or professional corporations? Are there previous acquisitions that may have occurred? As Denise mentioned in her presentation, you know, there was a covenant not to compete where there had been several acquisitions involved, and so, you know, did those purchase agreements all contain covenants not to compete, and are they all still enforceable? Are they on top of each other? Did they replace the previous covenant not to compete? And in vendor supply contracts, there may actually be provisions that the supplier may restrict contracted parties from competing, or particularly non-solicitation provisions are very common in vendor supply contracts. And then on the proposed agreements, if you're doing a due diligence or a transaction, they're often working on the transaction documents, which will be in place once the transaction is completed, and those frequently include purchase agreements, management agreements, and employment agreements, and those also you need to understand are the provisions. Do we need new provisions, or are existing contractual provisions, covenants not to compete, non-solicitation, are they going to be replaced by new agreements? So we can turn to the next slide and talk about in the due diligence process. The one of the most important things is understanding the total universe of the transaction. When you do a due diligence, as I mentioned, there could be a data room with thousands of documents. So one way that you frequently can handle on the documents and their contents is to have a management call to try to get an idea from management or key advisors, maybe it's their attorneys, if contracts do have restrictive covenants. And if so, are they all the same? Do they use a template? Do they use those things that Denise said? You know, do they have a certain on forum or choice of law? So those are, it's good to be able to ask those questions, and then be able to go and review the contracts. And you may do samples as opposed to reviewing every single contract. You want to make sure that you know that all of the different services that are involved. So is it physician services? Is it nurse practitioner? Is it optometry? Is it laboratory services? There may be a whole host of things and maybe different covenants related to different programs. Also, we have more and more national clients who are working on projects across the country. And so it's very possible that you've got projects that are in multiple states or in different contracts involving different states, and so enforcement may not be consistent across the country. They may be able to enforce in some areas and not others, and the client and you're going to want to understand where I have enforcement issues and not. And we often find that people use templates, and so they have the exact same contract across the country, and so you have to review very carefully to make sure that you know whether you have an enforceable agreement or not with respect to the restrictive covenants. And it also is key that you understand all of the different parties involved and who the contract is with. So is the contract with physicians or practitioners? Does it affect psychologists or dentists, optometrists, maybe therapists? Or does it impact all employees of a facility? That may not be enforceable if some of those may not be subject to restrictive covenants and some may. So again, it's important that you understand the entire transaction. You also want to know if the company has had any type of enforcement. Has it had any issues where they've had restrictive covenants, where they've actually had to enforce the restrictive covenant from somebody who is violating it? And if so, did they have to have litigation? What kind of success or failure they had? Or do they just have it in their contracts, but they never try to enforce it, which may make enforcement difficult in the future if everyone's able to violate them and there's been no history of any action. You'll also, in due diligence, want to know if any of the companies that you're looking at have current litigation, either as the plaintiff or defendant. It's very possible that they are trying to enforce their own restrictive covenants, or it could be that they've hired somebody and so they are now a defendant by someone trying to enforce a restrictive covenant for one of their existing employees. The ownership is also important because in the contracts themselves, they have provisions that state that upon a change of ownership or a change of control, that the restrictive covenant either is in effect or it's not in effect. And the issue here is that there is no standard change of ownership or change of control definition. It may be in the document itself, but in some cases it may ownership may be defined as changes of 100% of the stock or 100% of the assets. In other cases, it may be, a change in the majority of the board or a change in 50%. So it's important to look at those provisions along with the restrictive covenants to understand whether they're going to be enforceable or not at the result of the transaction. There are some facts which may even state that upon the transaction, the covenants are no longer applicable. So if there's change of ownership, a change of control, the restrictive covenants are then negated. And this is all information that's important to determine if you're doing the due diligence. It's possible while you do the due diligence that you're going to find agreements that are unenforceable. So, both David and Denise said, there are plenty of states that either don't allow certain covenants or that you may find that they've been drafted incorrectly, or there's been a court case come down that has determined that the restriction that was originally drafted is too broad. And so what do you do there? As a buyer or somebody who's looking to do a transaction, these are all things that you're going to have to take into consideration or redraft and have new signatures. There also could be reasons in the healthcare arena where you can't enforce a covenant, a restrictive covenant, particularly because it's not to compete, because of the corporate practice of medicine. Corporate practice of medicine is a prohibition on the general business corporation providing a profession, and it's called the corporate practice of medicine. That's kind of the overarching term. It actually applies to many other professions. Dentistry and optometry are some of the most common. And if you're new to healthcare, haven't been involved in a lot of transactions in the healthcare space, this may be a real eye-opener, and may not know that there are these types of restrictions on who can employ physicians, dentists, optometrists. The prohibition on corporate practice is state-specific and profession-specific, and so although, again, it's called corporate practice of medicine, there are some states that have a prohibition on many different professions. New York is one of those states that prohibits the employment of a licensed professional by a general business corporation in a significant number of the professions. Most of them, there's only a few exceptions. And then there are other states like Delaware, for example, which is a prohibition but only on optometry. Other general business corporations can employ other professionals. And then certain states like Michigan have a learned profession definition where it considers law and medicine and divinity as the learned professions. And so it's always interesting to have to tell certain professionals like nurses or therapists or optometrists that their professions aren't learned, according to Michigan, and they can be employed by general business corporations. Some states have no issue whatsoever. So again, when you look at these contracts, you want to know what state you're working with, so that you know whether there's a prohibition on having this contract in the first place. So we'll move on to integrating following a transaction. As Denise mentioned, there may be covenants. You're going to be drafting new agreements, and if you are drafting those agreements, where are they going to be entered into? Are the covenants related to the purchase? Are they related to the employment? And could they be in both agreements? Some of this may even depend upon your negotiations, pre-contract or your negotiations to start the deal, or even the letters of intent. So you want to have this on your mind at the top, so that restrictive covenants can be part of those early documents, so that they can be incorporated in later documents. It's always much more difficult to negotiate restrictive covenants when they weren't in some of the original documentation than at a much later time. So who provider contracts with? Are they with licensed entities, be say a hospital or a surgery center, even HMOs? They're to do certain things, like I said, in the corporate practice side. Many states have exemptions for hospitals or insurance companies, HMOs, to actually employ physicians, and so can you contract with them? Are there professional corporations involved? So it's just a professional corporation that already has patients that is looking to hire somebody or is buying another entity. Is a management company involved? Often with our private equity clients, there is a structure involved that has a management company and a friendly physician or a friendly professional corporation, and so there are provisions in the agreements between the management company and that professional corporation with respect to restrictive covenants. But again, a management company may not be able to enforce certain restrictive covenants because it's not allowed to actually practice the profession. So management companies have to be careful on the type of restrictions that they have with professional entities, because most states will say you can't prohibit the professional corporation from how it runs the professional side of the business. Some things to take into consideration. And then the sellers, if you're dealing with someone who's selling a business, you may have much broader latitude, as was pointed out before. So you may end up having multiple restrictive covenants with multiple parties. Could be a licensed entity, a professional corporation, and a management company. So a seller, it's very possible that they could be providing administrative services to a licensed entity. They may have professional services to a professional corporation, and they may also have an agreement with a management company. All of them may have different restrictive covenants and different enforcement rights. And as Denise pointed out, it is critical to have assignability or the availability of certain third-party rights to, for say, a management company to enforce a restrictive covenant if the professional corporation doesn't. So in drafting these, it's very important to take into consideration the points that Denise pointed out. And then finally, if you find that as part of the due diligence process and the integration process that restrictive covenants are not permitted, you look for less restrictive alternatives. So instead of restricting somebody from just the practice of medicine, perhaps they're just restricted from practicing concierge medicine. Restricted to certain competitors, as Denise noted, restrictions limited to certain activities. In some cases, it may be that you can't be an owner of a professional corporation as opposed to employment by, because they believe that ownership has far more problems with respect to the restrictive covenant than that's being employed by someone else. Or restrictions limited to other management companies. Companies frequently can ask that their professional corporations or the employees not contract with another professional corporation as opposed to an outright restrictive covenant that prohibits them from performing their profession. So that was quick. Nathaniel, I'll turn it back to you. I think we still have a few minutes left.
Thanks, Kevin. That was very interesting. Yes, we do have time for a few questions from the audience, which will take in turn. The first is whether there's a reliable state-by-state summary of the statutes and general common law for each state. And BNA does put out a treatise called Covenants Not to Compete, a state-by-state survey. And I think it's now in its 10th, 11th edition. So that's a resource for you to turn to. And the second question is, what is considered indirect solicitation? For example, is a newspaper or radio ad indirect solicitation, and should the contract define that term? I'll give my answer, but I welcome it to the rest of the group, and that is, I think, certainly depending on the situation, it does help to define down to that level. There are times when I out, for instance, the availability of an employee to add in a newspaper or radio once they leave, but they can have direct one-on-one conversations. And other times, I had disputes where this for indirect solicitation was not defined, and the question was, the patient ask the departing physician where she was going next, or did the departing physician affirmatively tell the patient that she was opening her own practice down the block? So those are things that you want to think about in drafting. Anybody else? One question that's come up, I think, for either Denise or David is, with respect to physician non-competes, how do you factor in patient preference for choosing their physician when you put together a restrictive covenant, a non-compete, or non-solicitation provision?
Good. And yeah, as I said before, that's certainly something if the covenant not to compete is challenged, that the court or whomever will be ruling on it is going to hold very high regard, is the patient's ability to choose their physician. So I've often seen provisions in agreements in which they say something along the lines of, nothing in here is intended to prevent any particular patient from seeing this individual or from choosing the healthcare professional of his or her choice, just to, kind of acknowledge that that's the key here. But just kind of generally speaking as well, there's the difference between a non-solicitation provision and a non-service provision. And certainly, in healthcare context, non-solicitation provisions are okay. Non-service provisions, where the physician is purportedly prohibited from rendering services to patients, tough one to get enforced.
Well, we're at 1 hour, which concludes today's webinar. In approximately 2 to 3 business days, we'll communicate the availability of the webinar recording and access to the PowerPoint materials. And I'd like to thank all 4 of our panelists and thank you, the audience, for joining us today.